Welcome to everybody who have joined us today. We're gonna talk about legal aspects of doing business in GCC region. My name is Devon, and I am Chief Representative Officer of Enterprise Estonia, based here in Dubai. And the GCC region can be very difficult, not only because of the local laws and regulations, but also the business culture for the Europeans, for Estonians, can be time to time hard to absorb, hard to understand. So today we will cover loads of details, loads of basics, but this 1 hour session should give you a good basic understanding about the generic aspects of the laws and regulations. And just one more thing before I introduce you to our guest speaker. If you have any questions, then please put them in a chat box, and we will take them at the end of our session. Our session is planned to be approximately 1 hour. So last 15 minutes, we're gonna leave for the questions and answers session. But now I'm very pleased to introduce you Mr. Constantin Frank Fahle, who is definitely one of the best and leading lawyers and legal person to talk about the rules and regulations in the market, and not only about Dubai, but more about the GCC and the Middle East in general. Constantin, please, maybe you're gonna add a couple of more words about yourself and introduce yourself as well. Thank you.
Yes, thank you. Thank you so much, Ege, for having me, for your kind words, kind introduction. I'm flattered. I will share my screen and just give you a couple of introductory words about the presentation, about what we do, about what I do. So as you've mentioned, Ege, we're talking about doing business in the GCC today. I will cover a couple of sort of the most important legal aspects in terms of market entry. My name is Constantin Frank Fahle. I'm a German qualified lawyer, and I've founded, together with my partner, the law and sort of tax advisory firm EMLTC, which stands for Emerging Markets, Legal, Tax, and Compliance. So we not only focus on legal aspects, but also taxation matters, double taxation, international tax law, direct and indirect. And of course, compliance matters, which is quite important in these markets to prevent you from having any negative backlashes in Europe. Now, let me look at this. Here we go. So what do? We basically work together with the C-suite, legal and tax department of large companies, but also investors themselves, and help them with regard to their market entry and localization strategy from a legal and tax perspective. We do business formation, that means company setup, but also corporate restructuring at the moment. And in particular, the last year, we were quite busy with downsizing measures in terms of employment law, letting people go or restructure the corporate structure to take on board some other investors and downsize. Of course, commercial contracts and other operational agreements, in particular, when you think about agency and distributor agreements, which I will talk in detail later, but also international assignments, meaning if some of your staff from Estonia, for instance, is going to be dispatched to the GCC, then national international tax, the dispute resolution and strategic negotiations. That's sort of one of the pillars that I work on a lot when you have issues with local partners, being the clients themselves who are not paying for the services or goods that you provided, or more complex when you're in a joint venture with them to basically exit that. So currently I'm in Jordan and I'm negotiating the exit of a large joint venture and meeting here with a local partner to find ways how the foreign shareholder can actually take over the shares and fully operate that company. Compliance and corporate governance, of course, we also do. We have our own offices in Abu Dhabi and Dubai. We have subsidiaries in Dhaka, in Bangladesh, and Pakistan, Lahore. And we're actually expanding now in South Asia and East Africa as well. At the moment, we do have a wide network sort of associated offices, in particular in Saudi Arabia, Bahrain, and Kuwait, and also other South Asian countries. So typically, we really advise regional headquarters that are based in the UAE on their Middle East, Africa, and South Asia sort of strategy. I'm currently involved in rolling out go-to-market strategies for Africa. So we're setting up a couple of offices and companies there in, let's say, Egypt, Ghana, and Kenya. It's very interesting at the moment. And everything's sort of tied up then together in Abu Dhabi or Dubai. We help our clients to implement these growth strategies and act as a one-stop service provider. I'll forward this presentation to Ege later, and I don't have any problem, Ege, if you then share this as a PDF copy. Good, that's the introduction. Now let's talk about the agenda today. I'll give you a short sort of introduction. GCC, what does it mean? We'll talk about vendor and product registration, very detailed about distribution models, some common pitfalls and respective risk mitigation you can do. And I'll give you sort of a conclusion about the aspects. As Ege mentioned, I'll probably need around 25 to 30 minutes to cover these slides. And afterwards, we'll have another 15 minutes approximately for the Q&A. So just feel free as we go along to type in whatever you have into the Q&A function, the chat box. So we'll cover that later. So introduction. Yeah, Gulf Corporate Council and its member states. So we basically have the GCC, which is a council of the 6 Gulf states, namely Bahrain, Kingdom of Saudi Arabia, Kuwait, Oman, Qatar, and the UAE. It's been in place since 1981. And it's a cooperation of political and economic relations. Well, we've seen a couple of major steps in particular when it comes to indirect tax, VAT, where they have taken a unified approach. A lot of the other aspects remain quite loose, and particularly when you think about local content, localization efforts, where each member state basically takes their own approach. So the GCC is not as sort of unified as the European Union is, for instance, in terms of one economic corridor. Having said this, of course, the GCC has the benefit that if you produce in one of these countries, that you can basically ship the products to another country. In theory, you would need to keep in mind that obviously product registration, vendor registration requirements will cause some administrative hurdles. So the GCC is the most important trading partner of the EU in the Middle East. There's the Union of Customs that I was basically referring to earlier, but please keep in mind there is no union of currency like there is in the EU. So each sort of GCC state, they have their own currency, which is typically linked to the US dollar. We've seen quite a tremendous development in the past years with regards to Qatar, one of the smallest but yet economically speaking powerful member states, where Qatar sort of got into a dispute with Saudi Arabia. The UAE were involved in this as well, and Bahrain, and that led to the so-called Qatar embargo. Fortunately, this whole situation was resolved back in 2020, late 2020, and basically led to the reopening of transport routes. A big issue was here, in particular from the regional headquarters in the UAE, that they weren't able actually to render services or ship over goods or to receive payments from Qatar. Interestingly enough, from a legal perspective, there was no real rock-solid legal base for all of these measures, in particular in the banking industry. So that makes it quite difficult. It was more of a de facto embargo, but again, fortunately, this was resolved more or less. So Qatar is back in the game. As I've mentioned, we have the VAT. There was a common understanding on the VAT to implement a 5% VAT indirect tax throughout the GCC. So far, the UAE, KSA, Bahrain, and most recently Oman have implemented this at a standard rate of 5%. KSA has, in light of this COVID pandemic, raised the indirect tax from 5 to 15%. Other than that, please note that the corporate income tax and personal income tax system varies. Generally speaking, there's no personal income tax throughout the GCC. However, there's corporate income tax in Oman, in KSA, and Qatar, most importantly. This has an effect on how you do business, in particular in terms of permanent tax establishments. I'll get to that in a second. So keep in mind that there's no real harmonization in terms of civil or any sort of trade law, commercial law, other than, for instance, in the EU, where you have these directives that then would basically be transformed into national law. We don't have this here yet. Sort of the only aspect that I've seen so far that is really significant is the VAT general requirement. And even there, we see that a lot of the times the respective countries will sort of take their own stance on how they deal with that. As I've mentioned, KSA deviating from this 5% standard rate that was actually agreed in the GCC framework. Vendor registration and product registration is probably, for those of you who are involved in the sale of goods, but also sale of services, one of the most important aspects. And it's important to understand that the vendor registration is extremely important for all of those of you who are dealing with official sort of bodies, in particular the national oil companies. And this process is basically where these governmental bodies collect the key information from the suppliers and the respective products, and to have them sorted in their internal system. The vendor registration is then an integral link for the supply chain. You need to keep in mind that the amount of time and administrative efforts you need to put into these procedures can be quite extensive. The vendor registration is basically a prerequisite then to doing business with governmental bodies. Please also note that throughout the private industry, sometimes this might also be necessary, and depends on the size. So typically, if you deal with big conglomerates, this might also be relevant. And registration with governmental bodies, as I said, may require the appointment of a local agent, or even having a local subsidiary that is able to carry out sales activities. So keep that in mind. So depending on who you're dealing with, this might have an impact on actually how you need to set up or structure your sales activity in the GCC. So these prerequisites might also, as I said, apply in the private sector. Now, the product registration is sort of a different aspect, which goes hand in hand with the vendor registration, but you need to understand that this is basically carried out through or with the relevant authorities. So it really depends on what product we're talking about. So it's a bit difficult to make general sort of statements here. But if you think about medical supplies, you might need to go through the relevant health authority and get approval and have that product basically registered. If we talk about food supply, for instance, it might be important to have the respective labels translated into Arabic and have that then stick to the respective product. So the product registration really depends on the local legislation and heavily varies from GCC country to GCC country, but keep in mind that typically it needs to be carried out prior to import, unless you have somebody who is sort of the logistics company who can take care of all of these aspects. Also here, this product registration and fulfilling local sort of compliance requirements in terms of putting labels into Arabic can be very time consuming. So please sort of plan ahead in that aspect. Now, the distribution models, typically, if we look at it from a access sort of perspective, and going up would be having a footprint in the market, and going into the time level, it's the intensity of the market penetration. You have in all these markets basically the option of carrying out a direct export, meaning let's say you have your offices in Estonia and you produce from there, or even from China, and you drop ship it from China directly to the UAE, that would be considered an export. Could be an export of sales also, where you basically have services that you render from Estonia and digitally sort of export them then to the GCC. You could then have, with a footprint, then a distributor or an agent that basically helps you to sell these products. The distributor obviously in his own name, selling off the stock of the goods, whereas the agent would basically on your behalf make the contact and get a commission for their respective sales. You then have the opportunity to register your own vehicle, corporate vehicle, a representative office or a branch. The rep office obviously being something where you can purely have marketing activities. So the rep office itself cannot sort of carry out any commercial activities usually. The branch itself would then be able to assist in certain sales activities, however, typically cannot carry out sales itself. So this one is quite interesting if, let's say, you want to carry out after sales solutions or measures, and you want to help your distributor or your agent who has sold the products for you or on your behalf. And then you basically also have, as the most intensive sort of form, a sales company. Of course, afterwards you can also think about producing locally, but I've left this out because from a market entry perspective, this is typically not that relevant. So the sales company then, of course, would need to have its own setup. It's a subsidiary, which to a certain degree can be 100% fully owned by the Estonian shareholders, but it depends on the sort of foreign direct investment framework in the respective target jurisdiction. So these are the four main aspects you need to sort of look at. Typically, investors start with a direct export, and then they see that whatever the goods they have is actually quite relevant to the respective market, and then they might decide to, grade up to an agent or a distributor, or go directly to a sales company. But that really depends on what kind of product you have and what your risk appetite is or your business case is. I'll run you through these four options and tell you a little bit about what you need to keep in mind. So the exports of goods, it's generally possible, and you don't need a commercial agency unless you're dealing with some special governmental body that actually requires that. But let's say you deal with some private company, and the private company would want to import some of your goods. It's just then only really relevant to understand whether the buyer, whether your client is actually allowed to import the products by themselves, whether they have a relevant import license, and if not, the customer would need to align with a local service provider. There's just one word missing. So that you need to keep in mind customs regulations, the import regulations, but also their specific sort of vendor regulations. If you, let's say, deal with Aramco or ADNOC, there they have some overseas offices that might allow you to sell from abroad. But again, this is subject to being looked at in detail. Then, of course, you need to keep in mind the VAT from the perspective of Estonia, but also from the perspective of the relevant GCC country. From the GCC perspective, typically these matters are dealt with on a reverse charge basis. And from the Estonian perspective, I'm not quite sure at the moment how this would be treated from legally, but you would need to check with your local tax advisor. Now, export of services also is possible, of course. Let's say you have a consulting firm in Estonia and you have a UAE customer, and you basically, provide them with some memos or some marketing consulting services. That would be considered as an export of service. The key question is always, where is the respective service actually performed? Now, let's say if the service is carried out within the GCC, let's say an installation or a maintenance or a commissioning of a power plant or some other industrial sort of plant, you need to keep in mind that you would need to have the relevant licenses to carry out such services, either on a corporate level and or on an individual level, meaning you might need to get relevant permits, work permits, etc. So you may also be required to get a foreign direct investment license, let's say in case A. If the company sends somebody but also commercial license requirements, let's say in Qatar and UAE, which is more or less the same. It's basically the respective approval that allows you to carry out commercial activities. Now, what is important also is that you have certain risks if you just enter into the market and then you invoice your services from Estonia while you're actually in the UAE or in KSA or in Qatar, in particular with regard to the Kingdom of Saudi Arabia, which has corporate income tax, because depending on the duration of the performance of the services in the country, there are some permanent tax establishment risks that might be triggered. So the kingdom could then argue and say, well, since you have carried out these services in the kingdom, you have actually created a permanent tax establishment which is subject to corporate income tax. Now, this is quite complex, but is also very comparable to what you see in other developed tax jurisdictions. So you should have heard this already before. On a work permit sort of basis, please keep in mind that if your staff is caught working, carrying out work in one of these GCC countries, typically they would be subject to detention, and they would then need to leave the country, and often would also get a travel ban, so they would not be able to re-enter the country. So this is extremely relevant for the plant construction industry, for instance, when you think about specialized service engineers. So if you only have a pool of, let's say, 10, 20 service engineers for a specific plant, and all of a sudden you have 5 of these who cannot go and cater to the GCC market because they have been deported, that is an issue. And the other aspect regarding the foreign direct investment and commercial license is that you might be subject to fines if you carry out commercial activities without proper licensing. And of course, this might also have an impact on future application procedures. Generally speaking, the question is how high is the risk actually of being caught? There, I see it really depends on in which industry you are active. Having said this, of course, this doesn't make it legal. If you basically cross the red light, it's still illegal. It's just a question of what risk appetite you have ultimately. It is quite expensive actually to navigate compliantly throughout these waters. Regarding sort of the work permit issues, you can work around that a little bit by getting mission visa. All of this obviously has changed throughout the pandemic. It's extremely difficult to get mission visas at the moment. So please keep that in mind. Then, of course, also from a VAT perspective, you need to handle that correctly in the country of origin. I'm quite sure that from an Estonian perspective, if the services are performed in Estonia and exported to the GCC, this would be sort of a zero-rated transaction. And then again, here in the GCC, it would be considered as a reversed charge transaction. Now, if you remember the graph, the next would be sort of a commercial agency or a distributorship. The most common form typically is an agency where a company or a person represents the principal for the sale of goods and or services against commission. And there it's very important to understand that the regulations governing commercial agencies is quite differing than from what we know actually in the European Union and Estonia in particular. The advantages are that you can have that market entry without actually having your own presence. You have a presence through a local business partner, but you don't have a company on the ground that you need to administer. You would have a certain degree of protection of brands, and would also have the possibility to ban parallel imports of people who might want to sell your products by importing them themselves. This is a disadvantage, not an advantage, excuse me. The commercial agency laws in the GCC tend to be quite protective of agents. So they're in favor of agents. So you need to know that. And depending on the jurisdiction where you're going to be active, this might have a heavy impact. You need to differentiate basically between a registered and an unregistered commercial agency. Typically speaking, the registration is necessary according to the law. But you need to basically check whether the registration is mandatory in respect of the respective products you're looking at. Let's say pharma and medical sector, let's say pharmaceutical products. Typically, you would need a registered agent who can basically sell these products in the target jurisdiction. Everything that has to do with defense is also quite subject to agency aspects. You might also have other regulatory requirements that make it mandatory to register an agent. That could be civil defense approval, let's say paints that have a high security factor in terms of fire and so forth. You might also have the necessity to register an agency through to the vendor registration process. So ADNOC, for instance, in the UAE says, in order to sell goods to ADNOC, generally speaking, you should register an agent. That the devil lays in the detail, and sometimes you can talk to ADNOC and just get a sort of a simple unregistered agency. So take a look at that. Registration can be advisable if you want to have brand products protected, as I said, parallel imports. If you don't register, which I would technically always, I would advise against registering commercial agencies, but if it's not possible to do so, please check what are the actions that can be taken. So typically in the UAE, for instance, they say if it's not registered, then the commercial agency law is not applicable. The same applies to Qatar. If you look at this, then typically the general civil and commercial law related regulations apply. And it is extremely important to have a well-drafted agency or distributorship contract. The termination by both sides is generally possible, but you should keep in mind that the termination clauses should be drafted well. What I see often is that these contracts start off with some sort of revenue-based expectations that then do not get tied back into the agreement. And if this is the case, then it is quite difficult actually to terminate for cause based on a breach of a revenue target if it's only sort of put into an email. Keep in mind that a new agent can, if it's not registered, generally be appointed at any time. However, the old agent might have some claims against the principal if it hasn't been terminated in time. So you might then need to pay a commission on indirect sales. So this also needs careful planning. Now going to the next sort of step of entering the market, that will be the branch or a representative office. Typically, these two vehicles are wholly owned by the parent company, so they're not a separate legal entity. So the parent entity is liable for all of the activities of the branch or the rep office. The branches, for instance, you will need to look at what are they actually allowed to do. Typically, branches are not allowed to conduct any sales activities. So what we see typically is that branches are used to assist sales agents similar to the rep office, but the branches can on top of that actually carry out after sales services. But there again, you need to be careful whether you can then register the branch with, let's say, the respective customer. Sometimes they have certain expectations on the setup in the target jurisdiction. The rep office itself is really only sort of like a window shop. You are limited to marketing, promotion, and liaison activities only. As I said, let's say you could have somebody, a sales assistant, but the contracts themselves need to be then concluded with the parent entity abroad, in this case with the Estonian company. But it is a good way to actually get people on the ground, sponsor them, and control this whole process. It's a good way to have a stronger footprint next to your distributor or to your agent to make some showcases on new products and also liaise with your customers. Now, the most efficient way then, of course, to enter the market is through a sales entity. There you need to understand the limitations of the foreign direct investment framework. In UAE, you still have this 49-51% rule. There have been some tremendous developments in terms of liberalizing the foreign direct investment law. The executive regulations, however, are still not yet implemented. So generally speaking, for sales entities, you need a 51% share that would need to be held by an Emirati partner. So that de facto means they control the entity. Of course, there's workarounds in terms of diluting the dividend claims that the local partner can make, but be wary of any side agreements that would not be enforceable in the court of law. You have certain FDI restriction in KSA regarding trading. It's possible to have 100% trading for an owned trading entity. However, there's quite significant capitalization requirements there in terms of investing, in terms of building up local workforce and creating know-how transfer. So if you team up with business partners, for me, one of the most essential sort of points is carry out business partner compliance checks. So what I see again and again is that investors tend to team up with the wrong business partners. And once you're tied in together through a shareholding structure in one company, it's extremely difficult to get out there. And this can only basically be prevented if you know who you're actually dealing with. So it's important to meet, to have several rounds of meeting, to also check who is behind the company that you're dealing with, potentially if it's an sort of a legal person. And then I always say negotiate from the exit. So how can you exit the venture in case it fails? That's obviously not always something that is on the mind of an entrepreneur, but it is extremely important to understand that if you do not keep this in mind, the exit itself might become very costly and time consuming. Then what's also important is to secure the ability to act through power of attorneys. Common mistake that is made here. If you do not have a power of attorney to basically manage the company as the foreign investor, or you're the general manager, your party has the ability to appoint the general manager. You'd still need power of attorneys to ensure that actually you can contract, you can act on behalf of the company, you can appoint lawyers, and so forth. So that's, for me, very important. The final point is securing banking authorities and ensuring that you have control over the banking accounts, the banking facilities, etc. What we've seen in the past is often that there was too much trust that might have ended in some bad situations where the foreign investor lost a significant amount of money because the local partner has made a run to the bank and withdrew most of the funds. Now, common pitfalls and risk mitigation. I already sort of touched some points, but I like to get into the details again. As I've mentioned, the business partner compliance check is one of the most relevant aspects that you should carry out. So understand that the person pitching an idea that you might find interesting is actually capable on acting on behalf of the respective entity, has the power to represent that entity. You should actually check the commercial license. That actually tells you what commercial activities the respective entity is allowed to carry out. You can check the articles of association. You would, of course, need to ask your business partner for this. This is often, in my experience, a task that is done reluctantly because people think this is going to harm the business relationship. But I would advocate for a very active communication there, that you need to check this, that your sort of compliance board in the background needs to have a look at these documents and so forth. Then you need to check the power of attorney and formal status of whoever you're dealing with. And of course, you should also talk to chambers, people like EASi, or advisors like me for assistance. Often people might, out of these industries, might have some concrete cases that they're familiar with where there are bad experiences with a relevant local investor, and that could basically cause you not to tie yourself up with these people. Commercial agencies, is very important to understand that if the commercial agency is registered, there's several protective rights for registered agents. As I said, typically these laws tend to be quite protective of a commercial agent. So registration may enable the agent actually to block parallel imports. I've seen this a lot, in particular in the UAE, where agents have sort of tricked principals into registering the commercial agency, and then only ask them to deregister themselves as an agent for a tremendous compensation amount. So depending on the market value for yourself, you either leave that market and do not basically touch it any longer, or you'll need to pay something in order to make business from it in the future. So the rules governing termination should basically be included in the contract. If it's registered, keep in mind that there's overlaying protective rights from the commercial agency law. So that's why it's really important to understand what you're doing. I would advise talk to a lawyer, somebody like me or some other colleague. The termination under these commercial agency laws might only occur in certain regulated events. So if you have written down certain termination rights in the contract, they might not be applicable even though both parties have signed them in good faith. And the deregistration can only be carried out through court order or by the registered agent himself. This is in particular true for the UAE. So based on the above, I would advocate that foreign investors should generally refrain from registering agency agreements, not to fall into this pitfall. But keep in mind, some government authorities may include the requirement to have a registered agent in the country. Otherwise, you cannot do business with this body. Now, this is probably the most tricky one, strategies to guarantee payment, because obviously throughout the GCC and in particular in the Kingdom of Saudi Arabia, we have had reported again and again that clients have issues in collecting debts, sometimes over 200 days or 350 days, which almost is a year, and that is really an issue. So there is no real reliable credit rating system that is accessible throughout the GCC at the moment. But what I would advocate for is do some trial transactions on a small basis, look if there's any recommendations for that particular client, review your structure, try to look at measures of security, of course, an advance payment or letter of credit. Rather have that and have it secured, even though it goes sort of against your margin. There's export credit insurance that you can get. However, keep in mind that that is quite expensive, or in some of these target jurisdictions, not even possible, because the credit insurer will not grant that product due to the risks. There's retention of title clauses that might help you, but you should keep in mind they might not have an impact against third parties. Let's say your customer then sells the respective product on to a third party who has no idea about the retention of title. You also have the issue of import, where typically the importer of record then from a civil perspective might be the new owner of the good. Then of course the retention of title clause has no meaning. Then you also have the issue of assigning claims. Let's say you still have a client that owes you, or a customer that owes you a substantial amount of money. You could assign, typically speaking, the claim, but under the GCC law, sometimes this might not even be possible without the debtor's consent, so it might not be an option. Take a look at that. Then, of course, we have post-dated checks as a means of payment. If this is the only measure of security, please understand that the security behind the post-dated check is the criminal sort of liability that the signatory has under it. The Emirate of Dubai, for instance, has liberalized significantly the approach that criminal and prosecuting authorities would take against bounced post-dated checks. So this is not the most and the best sort of form of security. I would advocate rather for letter of credits or the export credit insurance, if that's feasible for you. So this brings me to the conclusion And I think companies and investors need to really carefully consider the legal, but also the cultural framework of doing business in the GCC. It's quite different here from Europe. The regulatory environment is in some instances quite pro-local investor versus foreign investor. The choice of the right setup really depends on whether you want to have a footprint or not, meaning branch affiliated company, probably not for everybody the right approach in the beginning. It's nice to test the waters with direct export, in my view, then maybe using a distributor versus an agent, and look that the distributor or the agent do not get registered. Then, of course, as I've mentioned, business partner compliance checks are key for operating successfully. You need to know who you're dealing with. You need to understand who's your client. You need to understand that the client is actually capable of paying whatever they ordered. So you do have a lot of scam here, in particular in the UAE, where business partners will trick you into doing business with them, and on a de facto basis, they might not even be able to pay whatever you have. Then, of course, one aspect that is really important is to understand that the entrance hurdles to file legal complaints or civilly sue one of your customers are very high. The lawyer's fees will not be payable on the losing party's end. So let's say you need to file a civil case against one of your customers in Abu Dhabi, then you would need to pre-finance such trial. The lawyers and the litigators is quite expensive, and you might only get reimbursed up to, let's say, 1,000 to 1,500 euros, even though you might have spent 10,000 euros for your legal expenses. On top of that, court fees. On top of that, you will need to get translated documents into Arabic, because of course the courts will look at the case in Arabic language only. Then as a final point, you might need to spend more money on proper authorization, meaning the legalization and notarization of the power of attorney. So to put it in a nutshell, what I'm trying to say is that if you want to sue somebody here, it's much more complicated and cost intense than it might be in let's say, Europe, where you have relatively low entry hurdles in order to fight for your legal rights. So that's all I can share with you at the moment. I hope I could give you sort of a comprehensive overview. Of course, we can go into a lot more detail, but I think we do have some questions already, and I would be pleased to address these, Ege.
First of all, thank you very much. It was a very detailed and like a big presentation covering so many different aspects. And I think if I would take from your presentation one message, then that would clearly be that spend your money before you are entering the market, do your homework, because it will be much more expensive to fix it afterwards. So, but at the moment, please feel free to raise your hand or ask the questions. I know that you might have very detailed questions, so if we don't have the specific answers right now, then we definitely can get back to you. So, any questions so far? So I'm gonna have
it's always either a good thing or a bad thing. Either it was so boring that the people are scared of listening any further to me, or it's a good news. It was so comprehensive that all of the questions were answered.
I would truly hope that that's the option number 2. So from my side, and I apologize, I'm going to use much more simplified language and like to ask very simple questions from you. So basically, so often, and we have already also seen that like you mentioned the scams and especially some agents are attending some competitions, etc., with your product, etc. And apparently they say that, oh yeah, you won the tender. So what is the best way to basically check the background? So you mentioned the couple of things, so maybe just to emphasize one more time that if you have any doubts, what would be the like a basic ABC, how to start checking the background?
Well, I think the first aspect is that I think mutual trust is an extremely important aspect in doing business in the GCC. So this is not a hard legal fact or anything around that. So it means you need to build up that trust, and that takes time. Meaning you need to come, you need to meet, you need to sit down, have coffee, and understand is my business partner just somebody who wants to onboard me and is super happy to have whatever and a promising Estonian tech company under his name, and once he did so, not much is going to happen or not. How can you find that out? You can find that out through speaking to other investors. Let's say people that you might be in contact with, Ege, where you can basically just check that. So typically there's obviously a lot of big conglomerates who have a strong track record of attracting foreign direct investment, who have done a tremendous job. That might be somebody you should talk to. Of course, that gives them a much higher bargaining power, much more power, because they might be connected differently than, let's say, the average Joe. So it really depends who you're dealing with. But my advice would be take time. Don't do things in a rushed manner, because untying these knots is going to cost you much more time and much more money, or it will mean that you will have this market lost because it's blocked through a local investor. So my rule of thumb is actually when people want to, let's say, save the initial $5,000 or let's say $10,000 for consulting, not only legal consulting, but maybe also business partner compliance check consulting, they will pay 5 times, 6 times, 7 times at least that amount to undo it. So I mean, it's not rocket science. Meet with the people, try to understand their agenda, try to understand what can they actually do for you. Don't fall for the typical, I know somebody in the ruler's family stuff, which I've heard so and so many times. If you hear that, take the next exit and try someone else.
That's actually a really good point, that so often the main selling argument seems to be that, oh, I have connections with the Sheikh's family, etc. So always, whenever that comes up, then that's the first sign of please be careful. Also, from my side, I would encourage to use the LinkedIn to see, like, if you have like a common people, you can always ask for the introduction. You can always see the people, because people here in the business community, they use LinkedIn a lot to work in a professional way. So that's definitely one of the good resources to use. We have one question here. In Estonia, we have a general register where you can check every company basic data. But what would be the website, etc., in UAE for it?
Yeah, this is a very relevant question, and brings us to the point that the business partner compliance check is actually much more complex than it would be in Europe, where you have these registers that are publicly accessible. So what happened throughout the last I would say 9 months is that due to transparency movements, the UAE is working on that. You have this so-called UBO, ultimate beneficial ownership registration and declarations that now seem to find their way into a unified registry that you can access, I believe, via the Ministry of Economy. The issue is there that it does not show you all of the details that you would get, let's say, from a public registry that you could access in Estonia or in Germany. Saying you can get the name of the company, you can get the license number, you can verify what kind of commercial activities that company is actually allowed to carry out. But you might not even get the name of the managing director. You might not get the name of the shareholders behind that. In other words, it is quite difficult to get comprehensive information on that. This is mainly due to the fact that you have around almost, I'd say, 50 different authorities who are responsible for setting up companies or administering that, that being the 7 Emirates plus the various free zones. And the free zones in particular, one of the unique selling points in the past has been that you can set up your company completely anonymous. And I'm not talking even about these offshore vehicles. I'm just talking about simple free zone entities. So if you have a, let's say, a customer or like a company that you're dealing with in the Ras Al Khaimah economic zone, you will have no way to access their a registry. DMCC in Dubai, for instance, they have a limited access where you can basically look up who's in there. The financial free zones in Abu Dhabi and DIFC in Dubai, DIFC, they have a registry, so you can look up, for instance, my company there in Abu Dhabi. But again, it will not give you any information about who are the shareholders, etc. So in other words, the information you can get is limited, which is better than nothing, obviously. So we see that there's more steps that are being taken to ensure transparency. But please note that in general, the UAE was based, or the business models in particular for the free zones were based on the notions to have a certain degree of intransparency, because that's what investors actually built on. That's what they wanted. So it will never, at least not in the short run, be as transparent as Europe is at the moment.
Mm-hmm. Thank you for that. We have another question, and maybe you have an experience as well here. Would prepayment solve all the payment issues? Are companies in UAE ready to pay with prepayments?
The simple answer, or the answer to the first question is a simple yes. Of course, prepayment is the best you can get in terms of cash flow and in terms of realizing your claims, because you don't need to do any debt management or claim management. The answer to the second question is typically no. They're not going to pay 100% upfront unless you have a good or a service that is unbelievably good, or you're a monopolist, so to speak, in what you do, or you have an advanced price that is much lower than having to pay afterwards. So let's say you give a tremendous discount of 20%, then it can make sense for you, because basically having 80% is better than running after 100% that you might not get at all. So that could be an angle, but it really depends again on your service. If it's commodity, I don't see that that's going to work.
Mm-hmm. So, and I guess that's where what you already spoke as well throughout your presentation, that there are options how to eliminate the risk, like with the guarantee letters and bank guarantees, etc.
Letter of credit. For me is, in particular, if you talk about high value goods, the most relevant way to back it up. Of course, then I'm not too familiar with the Estonian sort of foreign trade facilities, whether you have ECAs that you can base your trade on, etc. But yeah, what always is good to keep leverage in mind. So I think it's good to understand that if there's anything that you can hold back from your service that makes the entire service work out. For instance, if you think about goods and you have a manual that you withhold, and you can only operate whatever machine it is that you sold with that manual, that of course gives you leverage, and you can basically say, look, I delivered what I told you to, you didn't pay me in time. So here it is, I'll send that manual only against payment, whatever it is, yeah.
Mm-hmm. There is another question here that is the face-to-face meeting more reliable? And if I sort of trust the person who sits in front of me as a possible partner, and it seems okay, is it okay, or like do I get more trust feeling when I have a face-to-face meeting? And if you don't mind, Constantin, I will take it. And because I'm Estonian, so I've been on the market for 11 years, and I must say that it's still time to time very hard to read different cultures, because remember, here you are dealing with more than 200 different nationalities. And the selling skills can be like phenomenal. And also, like, if you don't know the business in details, so all the references, etc., can be not so familiar to you. So what I would still suggest and recommend very strongly, that even if you get this like a good trusty feeling after the meeting, please still do your homework and check the background every time. So then we had somebody who wants to have the open microphone, then please. Mari, if you can give the mic to Mr. Mohammed.
Yeah, I did it.
Mr. Mohammed Bakroon, I can see, Mari, that the mic is still muted. Okay, it seems that
he can unmute it himself, I think.
Okay, Mr. Mohammed, if you can unmute yourself from your screen, then we can hear your question. Okay. Meanwhile, if there are any other questions, we would take those. Seems that we have covered all the questions at the moment. So thank you very much for your time, Constantin. I really appreciate. For all the companies who have attended today, I would say that the opportunity in the market is huge. We have UAE with 11 million people, growing market. We have Saudi Arabia with 34 million people living, and also like we can see a very high trend coming from Saudi Arabia. The market is booming and the economy is growing. But this session today was really to give you a very brief understanding the complexity about the laws and regulations in the market, and to encourage you to use more the local knowledge and help before you are entering to the contracts, before you are entering into the agreements. So yes, from our side, we are here always to help you, and we will share Constantin's details as well. If you have more questions, specific questions, or you would like to work with his company or team, then please feel free to reach out. But seems that right now we don't have any more questions as well. So thank you very much, everybody, and have a great day ahead.
Thank you, Ege, for having me. Thank you very much.
Thank you.